Finally then, we need to look at fundamental rights as a justification for derogating from internal market law. Derogating from means departing from or not complying with. Fundamental rights are engaged when treaty freedoms of movement of goods, services, persons and capital clash with fundamental human rights. This is more delicate than the carpenter situation. The issue is potentially highly problematic from the point of view of the union's legal order, because the key and core elements of union internal market law, access to markets, come up against a fundamental constitutional value of all union member states, human rights protection. Again, the Court of Justice of the European Union has navigated this difficulty with care, and always with attention to protecting the peculiar nature of the union's legal order, or at least its conception of that, which isn't the same as the conception of some constitutional courts in member states, especially the court's conception of the doctrine of supremacy or primacy of union law. Note the links here with the themes of legitimacy in the union, the claim that the economic overrides the social in union law. Here are some of the strategies that the court uses. You'll study this further when you study internal market law later in the module. The court uses consistent interpretation. Sometimes the court says that the interests concerned need to be balanced, and the member state's wide margin of discretion in making that balance is respected and protected. Sometimes the court says that it respects the fundamental rights at issue and the balancing need as in the case before, but it doesn't find that the member state concerned had discretion to make such a balancing decision, or that the member state had made the wrong balancing decision, or abstracting from a particular conception of human dignity, for instance, in the German Constitution, to a more general concept of human dignity shared by all the member states. Again, just pause the video for a moment here and make a note to link back here when you've studied these cases later in the module. Because when you study them later, you need to see that they are both internal market law cases, but they're also cases that have to do with fundamental rights. Finally, two more things to note. The relationship between the European Union and the Council of Europe's European Convention on Human Rights, and union oversight of fundamental rights protection in its member states. So looking at the first of those, the relationship between the Union and the Council of Europe's European Convention on Human Rights. Article 6.2 of the Treaty on European Union provides that the Union shall accede to the European Convention for the Protection of Human Rights and Fundamental Freedoms. Such accession shall not affect the Union's competence as defined in the treaties. Again, perhaps unfortunately for us, this is one of those examples where the text of the law is far from the empirical reality on the ground. After a process of negotiation, a draft agreement on accession was reached in 2013. However, in Opinion 213 in December 2014, the Court of Justice of the European Union held that the draft agreement was incompatible with Article 6.2 TEU. We don't know what will happen now. As Craig and de Burke put it, it is difficult to predict what the path forward will be. Bruno de Witte and Selja Imamovic, writing in the European Law Review, expressed the critical view that the Court of Justice has done everything in its power to make accession exceedingly difficult, if not impossible. Claims against the European Union cannot therefore be brought directly to the Court of Human Rights in Strasbourg. But the Strasbourg Court has accepted that indirect complaints against Union acts can be brought against one or more member states. The key case here is the Bosphorus case before the Strasbourg Court. The Strasbourg Court held that there is a presumption that a state intends to comply with convention obligations, and this remains the case when the state is implementing EU law obligations. However, that presumption is rebuttable if the protection of convention rights was manifestly deficient. Importantly, the Strasbourg Court retained for itself the power to check for manifest deficiencies, as the European Convention on Human Rights is, as the court puts it, a constitutional instrument of European public order. It's in paragraph 6. The reasoning is based on the idea of equivalent human rights protection in the EU's legal order. While both the Court of Human Rights and the Court of Justice of the EU adopt a position that they hold exclusive jurisdiction over their legal order and their own autonomy, in fact, the two courts are in general deferential to each other and manage between them differences in interpretation of the relevant rights without ending up in direct conflict. You can find examples of this on page 446 to 447 of the Craig and de Burke textbook. As for Union oversight of fundamental human rights protection in its member states, you will be covering this more in Lecture 7. For now, note that Article 70 EU provides a process whereby the Union institutions, on a reasoned proposal by 1/3 of the member states, may determine that there is a clear risk of serious breach by a member state of one of the values referred to in Article 2. These values, of course, include the rule of law and the protection of human rights. If there is a serious and persistent breach, says Article 70 EU, there is a further procedure to be followed. However, this legal route has so far proved utterly ineffective in terms of responding to constitutional developments, particularly concerning judicial independence in some member states, such as Hungary and Poland, which threaten the rule of law and human rights protection. Rather than using Article 70 EU, the Commission has relied on Article 19 TEU, which obliges member states to provide remedies sufficient to ensure effective legal protection in the fields covered by Union law. And the Commission has also started a process that is similar to its process used in economic and employment contexts, whereby the Commission produces a rule of law report on each member state. And the Commission's rule of law reports were produced last week for all of them. So, just by way of conclusion, let's look at this diagram, which is found on page 281 of the Barnard and Peers textbook. When we have a situation where fundamental rights might be raised in Union law or in the European legal space. So first of all, it could be a question of national law only, down the left-hand column, in which national human rights law will apply and can be enforced before national courts. The matter could be raised before the European Court of Human Rights in Strasbourg once domestic remedies are exhausted. Looking then at the middle column, if there is national law with a European Union element, so the member state is implementing European Union law, or the matter is within the scope of European Union law, or the member state is derogating from internal market law, the national human rights law and the European Union Charter will apply in an action before a national court. There could be reference by that national court to the Court of Justice of the European Union. The European Court of Human Rights could be engaged if there is a manifest deficiency in protection by European Union law. Looking then at the final column, if it is a question of European Union law only, the European Union's Charter of Fundamental Rights is applicable in a case brought before the General Court or the Court of Justice of the European Union in a judicial review claim under Article 263 TFEU. Again, there could be engagement of the Court of Human Rights. If you're looking for an extension activity, something else to do to boost or bolster your learning, have a look at this fact sheet from the European Parliament. This is the European Parliament's take on fundamental rights protection in the EU. This is bound to be a bit of a glowing report. Articulate the ways in which you might disagree with each of the claims that the European Parliament makes here, and what cases or other examples you might marshal to support your arguments. What should you be doing next? Well, please finish up or get on with the electronic workbook. Ideally, this should be done by the end of this week if possible, although we understand that if people have been unwell or unable to do it for any other reason, then there's a bit more time. You need to be starting your workshop preparation, and for that you need to be making contact with your operating team. If the information about your operating team isn't already with you, it's coming very soon as possible. And finally, don't struggle alone. Remember that we are here to support your learning through these various different mechanisms. So we would very much like to see you, and we hope that everything is going well with you.